So this is our second meeting about online privacy and digital trade agreements, and exactly whether our privacy is being traded away in those agreements. We've got three speakers today who are going to try to illuminate that question and explain exactly what is going on in these international agreements and why it matters for the future of our privacy rights. So we have today Heather Burns, who is policy manager at Org. We have Paul Bernal, who is an academic in Norwich and well-known on Twitter for a range of political interventions and privacy commentaries. And Michael Veale, who's an academic in London, who is particularly well-known over the last few months for his work on DP3T, which is a protocol which inspired Apple and Google in their privacy-friendly app protocols for proximity tracing, which everybody, including the UK government, pretty much has been forced to use or ended up with programs that essentially didn't work. And whether you think that's a good or bad idea, ultimately a lot of the work that they did was inspired by academics working with Michael. So those are three speakers we have today. They say that have a wealth of knowledge on this topic, and I'm really hoping they'll be able to shed some clarity on this question. But of course, also those of you who are listening and watching on YouTube or Facebook or via Zoom, you two are entirely welcome to ask questions. We'll make sure that the audience questions are brought to these three experts, so we can have a discussion that really answers your questions too. So I'll start off with Heather. I think is going to just talk through some of the broad issues that are taking place.
So thank you, Jim. Thanks everyone who's tuned in today to listen to us speak. One of the things that we've been working on in recent weeks here at Open Rights Group is the UK's post-Brexit trade deals, because these can be fiendishly complex and difficult things to understand, but it's necessary to scrutinize and read them for two reasons. Number one is that trade deals can be a means of trading privacy away. The recent Japan deal is a good example. Now that was something like 800 pages, and it was literally Excel tables about measuring the length of a grain of rice. But once you get down into it, what you do is exactly what we at Org did, which is find the 3 or 4 paragraphs that could have literally traded away UK privacy rights for UK citizens by creating means of data flows to Japan and then onwards to other countries with insufficient data protection systems. So it's really shifted a focus for us for how we defend your privacy rights, because we think of them as being certainly like domestic surveillance issues of regulation with the ICO, but this is where it becomes an international issue. And the second reason we do that, and the reason it is so incredibly important for us to do so, is that trade deals are not subject to parliamentary scrutiny. And this is something, unfortunately, extremely unique to the UK. They are not available for Parliament to scrutinize during the negotiations. They're not available beforehand. The first we're allowed to see them is after the trade deals have been signed. And the amount of time that you have to scrutinize these is pitiful. Sometimes it's, I think it was something like 10 working days. So it certainly keeps us on our toes in terms of spotting and working to do what we can to mitigate the risks to your privacy rights that can get traded away in these closed-door trade deals.
Thank you, Heather, for that admirably brief introduction. So move on to Michael for some introductory remarks.
Thanks. So this is a really big deal over the coming years, and you know, in a sense, it's all about where the UK imagines itself to be in the world. But it's not just that. So on one hand, we see the UK as imagining itself to be a sort of Singapore, a sort of low regulation in some areas hub, although Singapore's high in other areas. It sees itself as an offshore low regulation zone. and that's how it attracts back its trade. And interestingly, when we look at some of the trades, such as the UK-Japan deal, we're really looking at Japan winning a lot more in this deal than the UK does. So this is a kind of trend the UK is also keen to reverse. But it's not just about where the UK sees itself, but it's also a larger coalition of how the UK seeks to undermine the EU's adequacy regime going forwards, because the UK and its allies in US and so on really dislike the EU's adequacy approach, because it interferes with surveillance, it interferes with and it puts pressure on businesses in some ways. And we see all these dynamics coalescing. So we've seen dynamics coalescing around WTO challenges. The WTO has been pretty afraid, though it's not really seen that way, of tackling EU's adequacy regime because the EU is so big. And also the WTO operate in a way in which member state consent is also important in their processes. So it's hard to go against large blocks. But with the UK out on a small island off the coast, the UK becomes an easier target to have trade restrictions that are based on data struck down. Ooh, there's a car alarm. And on top of that, on top of that problem, we see, well, maybe the UK want the WTO to start to challenge this regime. So we kind of wonder if there's a few more issues there. The second and last thing I want to raise is the challenges, which are the things that are not being considered during trade. So already the EU's data protection regime is not really great for enforcement overseas. We see it's got quite sophisticated mechanisms for cooperation where data controllers are based inside the EU, but when data controllers are based outside the EU, a lot of enforcement is kind of based on hope. Even though there are obligations for data controllers to maintain representatives inside the EU, it seems for the European regime, those representatives can't be sued or taken action against, so they're not liable on behalf of the data controller that's elsewhere. And the UK is likely to replicate that. So unless we think about, have ambitious ideas for how trade data rights are going to work outside of existing blocks, then we're going to find that enforcement becomes very difficult. As more and more countries adopt data protection-like regimes, start to move data around, it becomes more flexible where companies can actually place themselves to serve different markets, and they may not get enforcement that we might want to uphold our data rights.
Thank you very much, Michael. And turn to you now, Paul.
Okay, I come from this from a very kind of historical background, really. I remember on the day after the referendum result, I just tweeted a kind of little offhand, so who's going to do a panel about data protection and Brexit at the next CPDP conference in Brussels? I tweeted that, and within a couple of hours, we'd already been asked to organize a panel and to talk about this stuff, because people in the field of data protection understood right away that what was happening with Brexit was going to be very significant in relation to data protection, in relation to privacy. And we had this panel in January 2017, bunch of people from all over Europe, lots of interesting issues raised. And I was just looking back at it now, and not one single one of those issues has actually been addressed or discussed in public. And I think this is one of the things that we need to be really, really clear about. These are huge issues, and they haven't even been touched upon. They haven't even been thought about by our politicians. I mean, it's understandable in one way, in that there are other bigger issues going on, but it's incredibly dangerous that we're not even thinking about this stuff when it's going to have a massive impact. And I wanted to raise a couple of points about the way that impact is going to work, because a lot of people say to me, well, how come this is an issue now when it wasn't an issue while we were in the EU, particularly adequacy? Why is it that we're going to have a problem getting adequacy now when we've been within the system for all these years and not that much has changed about the way we do? And you have to explain that while you're within the EU, the default position is that everything's okay. And effectively, you have to be challenged to be pushed out. When you're out of the EU, you have to prove that what you're doing is good enough, or you won't be let in. So it's a kind of, the default has shifted from being in to being out. And that means then we look at what our systems are here. We look at how bad our surveillance regime is. We look at how there are weaknesses in the Data Protection Act 2018 things like the exception for immigration enforcement, that may make getting adequacy much harder than we imagine it's going to be. And that's going to have a big impact. And some of the impact is kind of, we would like to think it's good in the sense that we're going to have to change our surveillance regime and get it all working out. I don't see that happening. And then the result of that is either we don't get adequacy, and then what do we do? And this is where I think one of the risks that we don't talk about enough comes into play. If we've not got adequacy in with the GDPR, we may start to think, oh well, we may as well give up and let's trade away all our rights. Let's go full openness of data to the US. Let's give full open data to everybody else, because there's value here potentially for us. This is one of the chips we can play, and we haven't got that many chips. We're a small country without that many rights. If we say, okay, you can have access to all of our health data, for example, that's immensely valuable. And we might be in a position where that's the sort of thing we start to do because we've got very little else that we can do. And we have to watch out for this. I mean, and I know Heather mentioned some of it, and Michael mentioned some of it. We've got a long history of these trade deals being done in private, in secret. TTIP, CETA, ACTA, all of that negotiated in private. And it's only when leaks come that we realize what's being taken away. The stuff that we have potentially to lose may be being gambled away without us knowing. And by the time things finish, there's not much we can do. And the final point I want to say here is also remember, because of the political changes, Boris Johnson's government can do a lot more without it getting proper parliamentary scrutiny than he could before. So stuff is going on we don't know about, and it may be pushed through without us knowing about. So that means that we have to be able to act much faster. We have to be able to complain much faster. We have to be able to do something about it much faster.
Thank you. Well, okay, so far so depressing. So we have got a problem with transparency, but it is also true that, for instance, the comprehensive and progressive trade partnership of the Pacific, TPP, is an available document. So it seems like we do at least have a chance to look at that. And we could start to examine exactly how bad that is. Perhaps that's an opportunity for us to start interrogating. And I guess there's also, in terms of what we've signed with Japan, arguably the material in that is also material which is likely to be replicated in, for instance, agreements with the USA. So although the transparency is a huge issue, is the issue here perhaps more about the level of understanding that Parliament, civil society, and all of us actually have? Isn't perhaps what we are going to sign up to fairly predictable at this stage? Yeah, go for it, Michael.
I think this is, talking to people who are interested in org is a bit of a skewed group, because people have an idea that, hey, technology is political and we would like a political vision of how we want technology to be. And that is a vision that parliamentarians simply don't have. I think even when you explain deals or consequences like adequacy and so on to parliamentarians, they're still looking in one step at a time, and they can only see one step ahead. I mean, the very best ones can maybe see 2 steps ahead. We need to be presenting a vision of where this is going, and this, so we need to be. This means we need to engage a little bit more than just sort of education. We have to be thinking normatively, because data protection cannot stay within the EU forever. Lots of countries are getting this regime around the world, and there's going to be, as data processing gets more complicated, there's going to be cases of cross-border enforcement, from Europe to Africa and back and forth, and to Asia, and all of these will start to become more appealing to companies, places to base, as you get faster internet around the world, as fiber and 5G roll out to enable companies to be based pretty much everywhere. And obviously the pandemic is changing where people are going to be based as well. So in the end, there needs to be regimes of cooperation. There needs to be fora for regulators to be talking to each other, for judicial decisions to be recognized in other countries, which is public international law stuff. And this, so I think what we have to think about is, where do we want that to be? And what is the UK's role in that? And if the UK is taking a back seat in trying to sort of undermine this or make it a very poor quality regime, then perhaps that's something that we should be fighting against more directly, and saying the UK is the UK is the first country to be part of this bloc, and then not to be part of this bloc, to take these rules with it to some degree. It is a great test case, along with Switzerland probably as well, and the EEA to some degree, but mostly Switzerland, to say maybe we can start here to create international bodies that actually span and create this dialogue. And Japan too, and New Zealand and Australia, countries that, maybe not Australia so much, but countries like New Zealand, from Canada, countries that have reformed privacy law and care about reforming their privacy law somehow to keep up with data protection in Europe. Maybe not fully or as completely as we might like, but getting these involved, that sets up the normative vision. And then what institutions do you need for that? Is it a UN body? Is it something else? So I think that's where we have to go, and that political internationalist vision might be something we can talk about a bit more. And then the scrutiny comes down to what extent are these trade deals contributing to Britain being a leading voice in an internationalist vision of data governance? Because if it's not, it's going to have problems in the future and fall behind.
Heather?
I'll second what Michael said about how hard it is to convey these issues to a non-org audience. Obviously, we're very niche, we're into this stuff, but the average person is not, much less your average parliamentarian. Something that always amuses me in any trade group meeting that I sit in is the catchphrase everyone always uses is, what is the chlorinated chicken of data? People want the example of chlorinated chicken, which is like, what is the toxic object that results from trade deals? And it's very difficult when it's intangible. And sometimes it helps if you talk about healthcare, NHS data, especially in the pandemic, when data sharing has been enabled, quite necessarily so, to facilitate the response, to facilitate keeping public health systems secure, but it's not always been safeguarded or used correctly. And the other half of that understanding is, it's not just the trade deal issues, which are very niche, it's the privacy issues, which are niche. Parliamentarians don't understand the nuts and bolts of data protection law. Obviously, it's our job to do so, but we have to spend a lot of time not just explaining why this is a problem, but you've got to drill down several layers to explain how this works and how this is going to affect it. And if you can get through that without their eyes glazing over, you've had a good meeting. We at Open Rights Group had contributed to a fantastic report, which did, the organization Which, the consumer protection organization, polling the UK, people in all sorts of focus groups across the UK about what their priorities were just as average citizens for trade deals, the UK's post-Brexit trade deals. And data protection privacy actually came in second beyond food safety standards. And one of the fascinating things in that report was that when Which asked the question about trade deals to places like the US, the question was put to them, would you be safe? Would you be happy with your data being protected to the US standard of privacy? And then Which would explain to them, do you know that the US has no standard of privacy? They don't have any sort of Gdpr style omnibus law. And people were absolutely astonished by that. And it's a really useful lesson in what people take for granted. We're so used to living with privacy protections, whether that was GDPR, the Data Protection Act, that we take it for granted. So there's a lot of public education in this role, both to the public and to policymakers, about just what it is at stake here that are getting passed away in trade deals without adequate scrutiny.
Yeah, I have something to add, or rather something to take away, in a way, in that there's a way in which it would be great for the UK to be a kind of leader in this, but in some ways the UK can end up being a leader in exactly the wrong direction. And I've been in a number of kind of interactions with government over the last few months, where, for example, we spend a lot of time talking about computer security and international cooperation amongst agencies and so on. and the word privacy basically doesn't get mentioned at all. And data protection is, if I raise it, they don't even ask the question I want to ask, and so on. And we have, at the same time, reports like the one that came out earlier this week, suggesting that we've got to get rid of, that we must stop encryption as much as possible in messaging and so on. So we need to be aware that it's not just that we're niche, it's that we actually are, in some ways, going directly counter to some of the more common trends among government and in the public debate, which makes the fight much harder, but also makes the fight much, much, much more important. And we just need to be aware this is not something that we will lead in necessarily the right way. And things like the attitude in the national data strategy, which I know all of you know more than I do, but it's something that I've been writing about for a very long time. The idea that data protection is essentially a bureaucratic burden and a way of stifling innovation, it seems to be built into the national data strategy, that's the attitude that we should have, rather than being a critical protection for fundamental rights that actually helps us. It's seen just as something we've got to kind of reduce the number of boxes to tick, and that's about all there is. So we have, before we can even fight in the positive way, we have to be aware of the stuff that's going on in the next way. And this cuts across a whole range of different government departments. And it's easy to say, okay, the Home Office are the kind of the bad guys in some ways, but DCMS does not have their eye on the ball that well either. And we've got a difficult job, I think, is perhaps the best way to put it.
Thank you. So I got a question here which is related to trade, but you know, I'll say it's sort of kind of the underlying question of the power of relative of different countries is perhaps the underlying trade bit. Philip Jackson asks about the fact that we've been hearing this week that the US might be moving against the large big data companies, in particular talking about breaking up Facebook. What do you think the chances are of Facebook being forced to sell off WhatsApp? And I guess as a sort of second part to that, is the action here all about what the US does, and are we essentially going to be sidelined and just watching what other big entities, particularly the US, but a certain degree Europe also, do?
I'll answer the second half of that question, which was about, you know, are we at the behest of the US? And in many ways we are, because so much of the work that groups like org has to do and all of our civil society partners have to do is because the best way to explain is we all have to duct tape around the United States approach to privacy. However, there have been some very heartening noises out of the incoming Biden administration that they're going to be making sorting these privacy and data protection issues with Europe a priority, which is certainly a breath of fresh air after the past 4 years of what we've dealt with. Now, one thing to touch on what Paul said that we talked about in our national data strategy consultation response is that is an opportunity for the UK. You know, they can help hold the hand of the US and bring them up to a basic standard of data privacy, because the US is culturally very afraid of the European model, and they're not going to leap from nothing to Europe in one step. Maybe the UK has an opportunity there to help it understand the basic elements of a good, healthy, robust, rights-oriented data protection framework, which the US completely, totally lacks. So I think things will get better in terms of the ability to have the dialogue after January when the Biden administration comes in. The devil will be in the details, but on all things data privacy and protection related, I think we have a better 4 years to look forward to than the 4 years we're looking back at.
Yeah, I would agree with most of that. We also have something to learn from the US in some areas. I mean, I've just been doing some work on facial recognition, and the work of various cities in the US and even states in the US to effectively ban or control the use by the police forces, and indeed in some cases private businesses, of facial recognition is something that we could in the UK learn from. I think our action in that direction is in the opposite direction. I'm slightly wary of what might happen in terms of Facebook, because it would be, I mean, I've been calling for the breakup of Facebook for a decade or so, and I would like it to be burnt to the ground if it was really up to me. And sorry for those people who are watching us on Facebook when I say that. But I'm not sure that the reasons that they're doing it are exactly the reasons that we would be interested in. To think that the only thing wrong with Facebook is their monopolistic practice is to miss actually fundamentally what's wrong about the way that it profiles and targets, gathers data, allows itself to be used as a tool for manipulation and so on. So again, we have to be careful about how the debate is managed and not kind of let ourselves be fooled into thinking there's only one thing wrong here that needs to be sorted out, and that's this kind of monopolistic trade economic power. And I think this is one of the interesting challenges for me when I saw the name of this debate. It's sometimes easy to be stuck with the economics of this, and that particularly politicians like to talk about economics. It's the economy stupid still rings true very much for politicians, even if Brexit kind of flies in the face of that in certain ways. We have to remember that it's about fundamental rights as well as about the economy. And we have to try to remind the politicians of that at the same time. I would like Facebook to be broken up. I have to say, I'm not very hopeful. And I'm sure you all saw the leak, I think it was earlier in the week, about Matt Hancock having acquiesced to Zuckerberg over a whole load of stuff in the past. We have a history of that in the UK, allowing more access to government for the big corporations than we do for anybody else. And I think the US is more likely to do some action in that way than the UK is, but we'll see.
Sorry if I'm interrupting you, Michael. You've just reminded me, Paul, that when the Interim Competitions and Markets Authority report came out, remember that 800-page beast at the beginning of the year, one of the appendices, or a couple of the appendices, were some insight into ad tech and those privacy issues, which was some of the most outstanding research I had ever seen, which was staggering that it came out of the Competitions and Market Authority and not the ICO. But where this all ties together to that sort of antitrust breakup process is that the CMA gets it. They understand that the privacy and the market dominance issues go together. And if you want to solve the privacy issues, start with those. We're certainly going to be doing some work here at Org in the new year about interoperability and competition as an enabler of better data privacy. So again, I think our work is going to get a lot easier in that regard, and that we finally have people who understand how those things work together and are going to dedicate the proper resources rather than just the Facebook blob, as we've worked with before. Go ahead, Michael.
Thanks. I'm less staggered than Heather that the ICO didn't produce the EdTech rule, but yeah.
I'm easily amused, Michael.
I'm staggered that it was a very good report from the CMA. I think I'm glad objectively that it was a good report from the CMA. I think the comparative is less surprising. So I wanted to kind of link to those two things. So I think the breakup of Facebook is an interesting point here, but it's also, again, that political vision of the future of the internet and how interoperable different services are. This is breaking up these players isn't going to fix the problem. It's going to take active intervention in order to restructure markets so they don't coalesce in nasty platforms again. And that's sort of a, not just breaking them up, but actually magnetizing the whole space. So it, as I think many org members want, that the business models of the internet somehow and somewhat mirror the open architecture of the internet, but not fully, but in some way they're more faithful to some of the underlying ideas of the internet. So that being said, that's where a lot of other digital rights that aren't necessarily data protection, but do overlap with this, come in. And in the blurb to this event, you also looked at the right to repair and similar rights. We see that some of these elements around algorithmic scrutiny and so on are in the UK-Japan deal, but of course the digital side of this is still not very well fleshed out in general, and countries will still be working with each other on these issues for years to come. We notice that Japanese companies in particular are eager to bundle, eager to deliver things as a service, are eager to work with proprietary hardware, and this is the same for many business models around the world. But if anyone's ever used Sony headphones, amazing products, don't ever install the companion app that comes with them. The Veale on this is frankly illegal, and it will try and send live data of what you're listening to wherever, because the cloud business model is really powerful. I mean, this is the country that was initially bringing us the idea that many great Japanese games, mostly they haven't rolled this out in Europe yet, are available on your phone, but the processing is done elsewhere. It's like Google Stadia as well, but before that, it's very much servitizing everything. So we see ourselves being rooted into these kind of positions. And when we might want to make policy interventions to say, no, that kind of thing isn't allowed, that's concentrating power in a very problematic way, there may be issues in trade that are designed to stop those interventions. So I think where we need to focus on this, European Commission, if it gets down the road of interoperability proposals, or if the Parliament puts some in and it turns into that approach to debating, it may be lighting a lot of fuses, which I think a lot of big platforms are going to be wargaming already about what can we lobby to prevent this, or to were they to put in an interoperability requirement, how would we then strike it down later, or how would we then say it's not going to work across these borders, or it's not going to work in the UK? And that's, I think, a concern. Now, I'm more optimistic that we can win this political fight because the UK has always actually been a leader in believing in interoperability standards. I mean, it's always been very proud of saying we can switch service providers and so on and do all these kind of things. And that's an argument, like an open data argument, has been successfully made among the political classes in the UK before. So I think we can, have more hope with pushing this, but it would require us to actually make this positive vision to UK legislators earlier on, not just we should change our surveillance law and so on. Actually, the last thing I want to just mention that we haven't really mentioned so far as well is it's always the elephant in the room, is when we look at adequacy and data transfers as well, the Schrems situation is this crazy asymmetric nonsense, right? Where when you're inside the European Union, you can't have your standards questioned by the European Court of Justice. They can't analyze, say, France's intelligence laws unless they relate directly to a telecoms company, for example, because it brings it into more economic law, which is European Union competence. But of course, you could analyze data flowing elsewhere economically, and that's how they start to analyze US and eventually UK security law. This tension is not going away. Like the Schrems 2 has blown this up again, and it is a real tension. And it's a real tension, which is a real hypocrisy. And this is, when we look at trade, this hypocrisy is going to be highlighted and blown up and put on banners and flown with planes over the place to delegitimize the criticism of surveillance regimes. So I think we do have to deal with this hypocrisy sooner rather than later. It will have to be resolved. It is like Brexit initially. It's a ticking time bomb that will have to be resolved in some way or another. How we deal with this is going to really matter, because if we resolve it in the way of just actually ignoring scrutiny of other countries, that's one resolution, not a nice one. But if we just leave it as it is, I'm not sure that's a sustainable way forwards either.
Michael, on that, I mean, aren't the European courts beginning to look at those questions a little bit through the action that Privacy International and others have put forward? Yeah,
the European Court of Human Rights has been a bit disappointing, I think, and many people have found it a bit disappointing in these areas. That's one approach. One approach is to put more national scrutiny on these areas, but it's going to be a long haul before you can do this. And particularly if you look at we're looking at Hungary and Poland or so on, in these regimes, there'll always be places in the European Union which won't have had those national discussions that you can point at that aren't being scrutinized within the bloc. So I don't see that as being a very fast way to solution. I mean, the rule of law now apparently is just advisory guidance. I've seen this morning in the European Union, so that's been downgraded slightly.
Thank you. So we've got another question that's come in, which I think is quite a good one. Without the European Union's protection, how can we in the UK protect our digital rights? The American administration is not going to care about British citizens and residents. What can we actually do about this other than join Open Rights Group to defend our privacy and online rights, which obviously everyone should do. What else, though, can we do? Everyone stunned silence. Oh, quick couple of people. So yeah, let's take Paul then.
Yeah, I've kind of this is the question that's been going through my head for the last 4 years, really, because I mean at the time of the Brexit referendum, I tried to say to people, look, I work in privacy. Most of our protection from privacy has its origins in Europe, one way or another, as we have it now. If you get rid of that, first by Brexit and then potentially by withdrawing or it's partially withdrawing from the European Convention, what chances have we got? I even wrote a blog in 2015 about what would happen if we left the European Union. At the time, it was speculative because I didn't think we were going to, but it's a big issue. We don't have in UK law really proper protection for privacy at all. We don't really have proper protection for freedom of expression, or indeed for a whole range of rights. And at the same time, we have a government that is cavalier with pretty much everything you can imagine. So yes, this is a massive problem, and what we do about it, there is obviously no magic wand. There is no simple solution to this. So we have to be fighting on all fronts, I think. I mean, is the way I put it. Yes, we have to work through NGOs like the Open Rights Group. We have to be talking to our MPs. We have to be using social media. I mean, it's one I bang on Twitter about almost everything all the time, but this is one of the things we have to do. We have to do our best to bring public attention to the fact that we have this problem, and to understand that the legal protection we have, which is less strong than it sometimes appears to be, it's getting much weaker as a result of Brexit. And it could get weaker further. I mean, things like the fact that, and I mentioned it before, that the Data Protection Act 2018 has this immigration get out. That's actually a big deal. And whenever I mention it, I get told I'm kind of getting all too geeky and technical about it. But it's a big deal because it shows essentially that rights can be watered down and exceptions can appear, and that actually the whole thing could eventually run away. We have to keep talking about it. That's the first thing. And we have to look for any opportunity we have. And I'd like to go back to something that both of the others mentioned. This is the CMA being actually good and getting it. One of the main reasons for that is that they've actually got some specific individuals who know what they're talking about involved in this thing. And one of the things I would like us to do is to try to get people who know what they're talking about into these places, into the when opportunities come up. For example, somebody I know is going to be working with a parliamentary committee on these kinds of items. When these opportunities come up, we should do our best to get good people to go into those places. So I mean, that's my story. I would say it's really hard, and that's the kind of the depressing bottom line for all of this.
So I'll start off by seconding Jim's statement that you all should join org, because that would mean that Jim and I can spend more of our time defending digital rights than we do dealing with grant funding spreadsheets. The second thing I'm going to say is that the National Data Strategy consultation, which we've just shipped, the closing date was Wednesday, and I'm sure that a lot of people listening to this will have been up to their eyeballs in it as well. But it was a very useful exercise for us to take in the scope and breadth of data protection and privacy rights as they could be in a post-UK, post-EU Britain. And as I think it was Paul said, they wrote the strategy very much in a sort of techno-geeky, Dominic Cummings type way. It's like, what can we deregulate? What can we get rid of to get that data flowing like water? Well, there is a reason data does not flow like water. There are safeguards and there are checks and there are balances. And if you view them as the strategy did, as just government bureaucrats getting in the way, you're misunderstanding the whole point. So the point we made in our data strategy consultation response is, why does it have to be about getting rid of? What can we do to add? What can we do to enhance? And the point we made is, it doesn't necessarily have to be about creating new systems and checks and processes and bureaucracies. It's about actually strengthening and enhancing what is there. I think a lot of people will be aware of the fact that we are taking the data protection regulator to court for not regulating data protection, which is ridiculous. I think a lot of people will be aware of things like the immigration exemption. Our colleague Sadia, who is our immigration manager, wrote the most incredible blog post about how migrant communities in the UK are not downloading or using the COVID apps because the immigration exemption does not protect their data from anyone, not from the NHS, not from the Home Office. And it is staggering that in a public health emergency, communities in this country who are here legally are having to take themselves out of the public health system because they do not enjoy the same data rights as you and me. So why are we talking about this sort of technocentric, let's make new shiny toys and gadgets when we're not protecting the rights and the freedoms of the people who are here already with the tools we could use? So I think the answer to your question, Paul, is maybe the strategy is a way for legislators, politicians, DCMS to stop pointing fingers and say what's wrong with other things. We should start pointing fingers at ourselves and say, what can we do to make things better with the tools we already have, with the systems we already aren't using, and with the regulators, frankly, who are not regulating?
I have one more thing to add. There's another strategy going on at the same time that I've been kind of involved in some of the consultations on, which is about digital identity, which is being effectively run by DCMS. This is another thing which, if we do it right, could be something that's positive. If we do it wrong, it could be exactly the opposite. And for migrant communities, for one thing, this is something that we've been trying to get across to DCMS, and I think this is what I was trying to say is, if we get involved in all these processes, then we have more chance of getting something to come out the right way. And it's quite hard, particularly for people like me, like you guys. We all have lots of things that we have to do, so getting us to do more things is obviously a bit of a challenge. So what would be good is to get more and more people who know what they're doing to get themselves involved in the various bits as much as they can. And it is about joining org, but it's about more than just joining org. It's about actually seeing, well, okay, what can we do here? What can we do here? And I don't mean, when I say what can we do, signing petitions and so on. I mean, I'm not sometimes a petition can work. It's not the big deal. I mean, actually getting involved in the processes as they go along, because many of these consultations that go on, actually they want to hear from people. They really do want to get ideas because they feel a little bit lost. So if we go out and do that, I think that's one of the ways that we can actually get things moving a little bit.
Thank you. Unless Michael's got anything else to add, I'll move on to the next question we have, which is another interesting one. So the British government is eager to strike a deal with the US. The US administration may want us to weaken our anti-surveillance standards as part of a deal with the US. I think that's certainly true for data protection. Can they be stopped? Can MPs vote or pressure the government to amend or change trade deals? start with you, Heather, I think. Do you know a little bit about the process?
I was going to give Michael a turn, but thank you very much, Jim. As I said, it remains to be seen how cooperative the Biden administration is, but I am more optimistic than I would have been with he who must not be named. The surveillance issue continues to be the one that is going to stand in the way of anything, US or UK. And I don't know the extent to which we can have any influence on that any more than we already do. It's a fiendishly complex issue. They are not going to get rid of that surveillance for the sake of a scrappy digital rights organization, much less us. So I do feel better than I would have a month ago on that, but it remains to be seen. They should. MPs absolutely should have the scrutiny, and it needs to be done in the open. It cannot be done as part of a Japan-style trade deal where we only get the document after Liz Truss signed it and have literally an overnight to go through it. We don't want to be in a situation where the Senate has more oversight over our privacy standards than we do. But if it goes through a trade deal as it did with Japan, that is exactly what will happen. And the irony to me is that, we left the European Union because of the issue of sovereignty and taking back control. And when these issues are folded into things that we can scrutinize, we have given away our sovereignty. We've literally cut off our nose to spite our face. So while we may not be able to solve the intricate issues of the Five Eyes surveillance and PRISM and Tempora, what we can do is demand that those issues are dealt with publicly in the open through multilateral stakeholder engagement and not through closed door trade deals where the documents are digitally signed so they can trace any leaks.
Michael.
So I think one area that we haven't really talked about that relates to some of the complexities of any deals with other countries is onward data transfers. And I think that there's one aspect of those which is quite interesting. So an onward data transfer is when I send data to Japan and it sends data to Vietnam, but Vietnam doesn't have a agreement with the EU or the UK or anyone who was before, and that data could relate to somebody who's resident in one of those places. And it's a risk. It's a backdoor way of moving data around through an intermediary, and an intermediary the UK probably like to be in some regards. So this has been dealt with in different ways. In the EU-Japan adequacy agreement, there's, and I think this is a bit of a problematic and strange way they've dealt with it. They've dealt with it by pasting on consent and saying that effectively individuals whose data is being moved to Japan can consent to onward transfer, and if they don't, it can't happen. And they put this in a series of rules that are annexed and being put into Japanese law and various other things. But consent is a pretty easily coerced aspect, and it's just consent needs to be information about this has to be provided to the individual. So it's very likely it will end up in practice buried in terms and conditions and privacy policies, regardless of whether that's actually legal or not. But maybe more interestingly is consent for international data transfers in the GDPR is a really exceptional thing you should be using. It's actually specified in the GDPR. You shouldn't be relying on consent the whole time. It's really just, you need to transfer data to a country that's not adequate. Consent will do it in a pinch, but cannot be relied upon routinely. So I wouldn't be surprised if this gets challenged and the EU-Japan deal gets challenged on the basis of onward transfers. Particularly, you maybe won't get challenged tomorrow, but as I say, countries are adopting data protection laws all over the place, and there's this intricate web emerging of countries that are going to be moving data around. And if we do see a decentralization globally of the internet economy a bit more, then and liberalization of that in general, then and liberalization there, it kind of means moving away from California rather than kind of actual other limits. But then we will come into those issues, and they will, I think, spark. Now, why do I mention all this? So, because imagine the UK, and it's probably quite a valid thing to do, says, okay, well, we'll strike a deal with Japan, adequacy, and imagine people actually care enough to put an onward transfer clause in, which is asking already, because they might just not bother with that kind of clause because it was politically contentious already in the European Parliament and so on. But so say, imagine they do that, and they say, okay, we'll do the EU one. We'll do this EU consent thing. Well, the Court of Justice may end up striking down that aspect of the EU-Japan clause, but it lives on in a zombie form in the UK agreement. So we'll see these divergences start to emerge in loads of really arcane technical areas in data protection, and each of those will be like little, beads that you find, the polluting beads in your shower gel. Not your shower gel, because I went to another country before and they still got them in the shower gel, these micro beads. So they cause friction. All these little friction causing issues that will add up to a significant legal risk for the UK and other countries internationally. So we have yet to see how the UK will in practice deal with divergence in technical areas and the CJEU, but I'm worried about the boring stuff they're diverging, because that's, that will cause some explosions, I think, and people will be like, why is that exploding? It's really boring, but there will be explosions.
Thank you.
It's almost a case of be careful what you wish for, you just might get it, because we heard all these years of we need to do different things from the EU, we need to diverge from it, and now they're actually doing it, and they're creating chlorinated chicken toxic pellets in the shower gel of data protection, and that is the worst metaphor you'll hear from me this week.
And we literally don't really care about that. I mean, half the things that are diverging, people in the UK and MPs also don't care about the consent regime for onward transfers to Japan, which is why I say UK can put it in good faith and end up diverging and then be stuck in a strange situation. And then it may become politicized, where they end up not taking it out because they don't want ideologically to follow the CJEU,
And it gets back down to having to explain the basics. It's like they hear data flows. What's wrong with data flows? Why would we want to stand in the way of data flows? And go ahead.
So the data adequacy agreement, data adequacy framework is a way to enable data flows, right? I mean, it's a huge international system for allowing data to very easily move from one country to another. Now, it's interesting because the UK signing up to agreements which are saying let's have lots of data flows. It's also saying we want maximum, we actually want to protect privacy, right? And that I think is perhaps the unspoken and thing we need to examine in this last little bit of this discussion. We have an international system for data flows that works very well. The government says it wants data flows and to protect data protection at the same time. Is the government actually agreeing with us and saying that adequacy is all fine and that's the way to go? And or is in fact the government trying to have its cake and eat it? And if so, how and why is the government managing to claim that effectively there is nothing wrong here and we should all kind of not even be having this discussion and we're just wasting everybody's time?
Okay, so I'll just say a little bit about my perspective on that. I think there is a disconnect here between privacy and data flows. When it sounds like data flows, they don't think it has anything to do with privacy, it's just data. Data is good stuff, data is analytical stuff, data can give you insights that can help society and so on, without actually having any human effect. So what we have to do is to actually make sure that people, and by people I mean the MPs, anybody else, the media, because the media is still, with a few honourable exceptions, not tremendously good. Though I would say one thing I've really appreciated about what's happened with the pandemic is that a few extremely good journalists have come to the fore on some of these subjects. We need to make sure that they understand that when you say data, you mean stuff that affects us and that can be used against us, as well as stuff that can be useful. And we need to also challenge some of the assumptions about, things like the anonymization of data and so on. We've banged on about it for years and years and years, but it still doesn't get enough traction. And I still have people in the health field saying, "Oh, there's no problem. It's all anonymized. It's all easy. There's no risk to anybody." And I don't know if you saw, there was another story that came out, I think it was this morning, about the algorithmic decisions about healthcare that were made on the basis of entirely racist assumptions, and meaning that white people were getting faster healthcare than black people in a number of important places. We need to use those kinds of things as a way of showing guys, you need to worry about this. You need to be concerned about this health, this sort of thing. It has an effect. That effect needs to be under more scrutiny, and we need to be aware that it could be a problem. That's the only way that I can see that we can get more attention on it in the way that we need to have it.
Anything from Michael or Heather?
I mean, I think just pushing the story's normative vision of this really matters. That we need to start illustrating it, not just in the sense of the kind of war stories that Paul is talking about, but actually, okay, imagine we had an internet that looked a bit like this. Imagine things were actually, you know, you could not be locked into services. You could talk to your friends who are on different services. You could actually have competition, and then you can sell it through the language that people in the UK and legislators might like. Oh, then, you know, a small company in like the north of England could set their own social network, and people can actually use it without feeling it's detriment to the rest of it. And you can have new hubs and new, you know, I just like it's. I think the problem we have is for most people, it just seems so far-fetched. The idea that you can have a world where platforms are not the be-all and end-all of people when they go online, single platforms, just seems madness now. But a few years ago, that really wasn't the case. It was easier to explain it then. But then a few years ago, many MPs didn't use the internet much at all themselves. So that was, we haven't seen a world where MPs are online and also, you know, and also kind of need to make decisions about this. So I think that's what we have to do, and it's going to be really tough. But I think we haven't done much work of presenting this new vision, and it's going to require actually creative effort to communicate it. And maybe what it needs is a sort of White Mirror TV show, not in a sort of racial way, but in some TV show that shows, oh, in the future, actually things, just as a side point, like, Star Trek's like, oh, we could have a world without money. Like, we could have a world without platforms, but it's just like a side point of a show. People are like, oh, that's normalized. I guess we could aim towards that as well.
And without it accidentally becoming a dystopian vision, because whenever there's this wonderfully bad book called Data for the People: How to Make the Post-Privacy Economy Work for You, by one of the guys who used to work for Amazon. And it's all optimistic, but actually by the end of it, you think, oh God, I don't want anything like this to ever happen ever again. I mean, this is just a complete nightmare, but he sees it as a wonderful, perfect future. So we have to be a little bit careful about that.
I mean, from my perspective, there was a question on the National Data Strategy consultation, which is, what do you think is the next country we should focus on for a trade deal in terms of data?
Lesotho.
Sorry?
Lesotho.
Well, I decided to throw a spanner in the works, being me, and I said Ireland, because, we're focusing on these sort of big picture, transatlantic, big data issues, and could we please sort what's about to happen with data protection on the Irish border first? Because if we cannot sort how we deal with data domestically on an everyday level, we are not going to have much standing in being the world leading sovereign nation outside the EU that can set a third way between the anything goes American system and the overly bureaucratic European system. So perhaps the thing we'll need to deal with in the new year will be having our wings clipped a little bit in terms of our ambitions if our failure to deal with domestic data flows issues can't even be resolved.
Thank you. Okay, so we're just a couple of minutes before the end of this chat. I think it might be just worth everyone maybe making some concluding remarks. I mean, it feels like this is a very, a situation which is quite dangerous. There's a lot of power imbalances here. We've talked a little bit about the European Union's role in this and the United States' role in this. Michael at the beginning was talking about the sort of general coalition that is building around undermining adequacy and that as a sort of safe way of, or relatively safe way of doing data transfers. And of course, as Heather was just saying, any minute now, there are big questions around just the continuity of adequacy. I mean, it's been I think, a very interesting discussion. Talks a little bit about the sort of forward moving things as well. So I just kind of ask, maybe how optimistic are each of you that something can be done here, or is this just basically, are we just watching a car crash?
I think something can be done. I think not just in relation to the UK, the biggest thing that we could do as advocacy organizations around the world is come up with an idea of what the future should look like, particularly if we get organizations outside the EU says, look, we're all fighting for privacy in our country and it's getting there slowly, like New Zealand or somewhere like that, or Canada, and saying, look, where does it go from there? Because we also know the adequacy regime in the European Union is also broken. It's broken. The EDPB doesn't really function properly, but also it doesn't. There's no way for it to interface with other high-quality regimes outside that makes any sense. Like, you can have adequate data flows. There's no regulatory cooperation. They can't say, "Oh, can you go and help me like bust this company that's dealing with European citizens?" That mechanism doesn't exist. So there's huge gaps in this so-called one-stop, the one-stop shop that deals within Europe to help regulators collaborate with each other around data issues doesn't exist with adequate countries, doesn't extend to them too. So we need to think about what's the next thing beyond adequacy. That's not going to last forever. That's Europe saying, okay, now we're starting to get these mutual recognitions, but what happens then? And I think that's what we need to focus. So a coalition of organizations around the world saying, okay, we've got this idea of where we have to go. How do we get there? We need to lobby for due process in surveillance law in a national country so that it actually starts on an even playing field. Make sure the privacy law in the private sector is up to scratch without things like the immigration exemption in the public and private sector that Paul was talking about. And then we have to think about regulatory cooperation, regulatory capacity, maybe start making networks. There are all these things like the Global Privacy Assembly, GPA, that are maybe spaces to get involved in with the regulators talking about this. Maybe it's a UN thing, maybe, give it to a Californian company to run the domain name system and privacy. Why not? It could have some sort of crazy other international organization style. But other than that, that's, I think, the place where we can get hope here, because the hope doesn't have to come from lobbying the UK. The hope can come from outrunning it on creating a regime that affects everybody, and the UK effectively has to sign up to, because this is the UK's grand new age as a rule taker. Why don't we take advantage of it as advocacy organizations?
Great.
I'm going to have to go in about 1 minute, so I will just say a tiny bit. I am actually more optimistic than you might think, and partly that's because in some ways Brexit has been a bit of a wake-up call for the whole of the British civil service in particular. They've suddenly found, we've got to do some stuff now that we used not to have to do. We used to have to rely on the European Union to do it all. Now we've got to do it. And they've started asking around, and they have given certain people certain opportunities to do stuff and to give them advice that they wouldn't have listened to before, because they thought this was beyond us and we're going to actually kind of avoid it. This is a chance for us to get involved, and they want help. They may not realize the kind of help we're going to give them, but they want help. And if we provide that help, there's a chance of actually steering the ship in a more positive direction. And with that, I'm afraid I have to disappear. Thank you all very much.
Thank you.
Thanks, Paul.
Thank you, Paul. So Heather, some concluding remarks?
I am strangely optimistic. It might not seem like it from much of what I've said. My worry, though, is that we end up with a domestic two-tier system, which is that we actually do this completely wrong way, and we have a sort of European level, if not clone, a European adequate standard for international transfers, but diminished privacy standards domestically. I mean, we've seen everything that's happened with COVID. We've seen the A-level algorithmic marking standards. We've seen what happened with the COVID view last week, that we learned that councils were looking at people's apps on their phones and obviously acquiring third-party data broker information to create an algorithmic score of if they might break lockdown. So I'm actually worried that we're headed towards a two-tier system of privacy, where you have better privacy rights if you're dealing internationally, but not so much domestically. And as Paul said, let's think of what it is we actually want to do about data, about privacy, and about regulation. And the data strategy, I think, could be an opportunity to do that the right way. But as I said, it's about enhancing and strengthening what's there, whether that's safeguards or regulation, which is virtually absent in the UK, rather than going on a sort of zealous, Dominic Cummings inspired, deregulate, get rid of it, and do whatever the hell you want with people's data.
Thank you very much. Okay, well, thank you again to all of our speakers and to everyone who's been listening, whether it's on YouTube, Facebook, or hopefully elsewhere. And thank you for the questions that we had. We'll be back in a few weeks, no doubt, other side of Christmas, with more topics and more discussions on digital rights. And in the meantime, if you haven't joined Open Rights Group, please do. It's our website, openrightsgroup.org, and you can join up there. Thank you very much.